The subtopic is closed corporation. Tingnan natin yung mga unique features ng closed corporation. A closed corporation is one whose articles of incorporation provide that. Ito na yung mga unique features niya. All of the corporations issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than a specified number of persons. That is, not exceeding 20. So, yung closed corporations, not more than 20 stockholders lang. All of the issued stock of all classes shall be subject to one or more specified restrictions on transfer. Para ma-maintain niya yung maximum number na 20, expect tayo na merong restrictions on transfer to. Dahil kung wala, say there are 20 stockholders, yung isa, binenta niya yung shares niya sa dalawang tao, madi-disqualify na. 20 minus 1 plus 2, 21 stockholders na yon. So, merong restrictions yan on transfer. The corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. Kasi kung ibibenta niya yan, yung shares of stock niya through the stock exchange, baka in a matter of seconds, madi-disqualify na siya. Kasi marami yung bibili doon sa stock exchange. So, shall not list in any stock exchange. A corporation shall not be deemed a closed corporation when at least 2/3 of its voting stock or voting rights is owned or controlled by another corporation which is not a closed corporation. Disqualification yan. For example, yung closed corporation, meron siyang stockholder, open corporation. Yung open corporation owns at least 2/3 of its voting stock or voting rights, madi-disqualify yan as closed corporation. Pero say for example, majority lang yung kay open, hindi yan madi-disqualify kasi dapat 2/3. Next page. The articles of incorporation of a closed corporation may provide that the business of the corporation shall be managed by the stockholders of the corporation rather than by the board of directors. Dito sa corporation law, yung creation ng board of directors ay very important. Kasi siya yung nag-exercise ng powers of the corporation. Hindi makagalaw yung corporation kung walang board. Pero dito, pwedeng walang board. Pwedeng i-manage directly ng stockholders. Dahil nga siguro yung number niya ay very small lang, not more than 20. So another unique feature ng ating closed corporation yan. The following companies may not organize as closed corporation: mining, oil companies, stock exchanges, banks, insurance companies, public utilities, educational institutions, and corporations vested with public interest. Bawal mag-organize as closed corporation. Number 2, validity of restrictions on transfer of shares. Restrictions on the right to transfer must appear in the articles of incorporation, in the bylaws, as well as in the certificate of stock. So, dapat nasa 3 documents na yan. nag-a-appear yung restriction. Kasi basic right yan ng owner ng property, yung right to transfer. Dapat alam ng bumibili ng shares of stock na yan na mayroong restriction sa transfer. Otherwise, the same shall not be binding on any purchaser thereof in good faith. So para maging binding, dapat nag-a-appear yan doon sa tatlong documents na yan. Articles of Incorporation, Bylaws, and Certificate of Stock. The restriction shall not be more onerous than granting the existing stockholders of the corporation the option to purchase the stocks of the transferring stockholder with such reasonable terms and conditions or period stated therein. Kasi baka yung restriction absolute na hindi na matatransfer ng stockholder yung kanyang shares of stock sa ibang tao. Say for example, pwede daw ibenta ng stockholder kung i-offer niya muna sa corporation yung shares of stock niya at 10% of the market value. Siyempre, kung ikaw yung stockholder, ayaw mo niyan. Kung yung market value ay 100 per share, bibenta mo lang doon for 10 pesos per share. So parang absolute restriction, hindi naman reasonable. Or, ibenta mo sa corporation daw at market value, pero payable after 5 years. So siguro, hindi na ma-exercise yan. Dahil yung reason na bakit ibenta yan, baka nangangailangan ng pera. Babayaran pa siya after 5 years. So, hindi na yan may exercise. Hindi yan reasonable. If upon the expiration of said period, the existing stockholders or the corporation fails to exercise the option to purchase, the transferring stockholder may sell his shares to any third person. Next page. Preemptive right. Yung preemptive right, ito yung right of first refusal. Bago ibenta ng corporation yung unissued shares niya sa ibang tao, i-offer niya muna sa existing stockholders. Yung purpose o reason para ma-maintain ng stockholders or particular stockholder yung interest niya sa corporation. Like for example, he owns 20% interest and yung corporation plans to sell 1,000 new shares. Yung stockholder with 20% interest has preemptive right doon sa 1,000 shares to the extent of his interest, that is 200 shares, para ma-maintain niya yung kanyang interest doon sa corporation. Magiging 20% pa rin yan. The preemptive right of stockholders in a closed corporation shall extend to all stock to be issued, including reissuance of treasury shares, whether for money or for property or personal services, or in payment of corporate debts, unless the articles of incorporation provide otherwise, including reissuance of treasury shares, not only from unissued shares, whether for money or for property or personal services, or in payment of corporate debts. Number 4, withdrawal of stockholder. Withdrawal of stockholder, ito yung parang appraisal right niya. When we discuss appraisal right, makikita natin doon na very limited lang yung instances wherein a stockholder can withdraw from the corporation. Very limited instances. Pero dito sa closed corporation, parang maluwag yung law. Any stockholder of a closed corporation may for any reason, doon sa appraisal right, limited instances. Dito, any reason, compel the said corporation to purchase his shares at their fair value, which shall not be less than the par or issued value, when the corporation has sufficient assets in its books to cover its debts and liabilities exclusive of capital stock. Dun sa ordinary or open corporation, nire-require ng law that there must be enough URE, unrestricted retained earnings. Dito, sufficient assets in its books to cover its debts and liabilities. So, sinisigurado lang ng law na mayroong enough assets na pangbayad dun sa liabilities. Say for example, total assets equals liabilities plus capital. Yung total assets ay 1 million, liabilities 300,000, yung capital ay 700,000. Sinisigurado lang ng law na merong enough assets to satisfy the liabilities. So, yung pwede niyang ipamigay o risole ay 700,000. Yung exclusive of capital stock, ibig sabihin yan, capital or equity.